Hi everyone, I'm David Fisher, and this is Presidential Chronicles, the series of books and videos on American history as seen through the lives of the Presidents of the United States. This episode is from the life of Abraham Lincoln, and the focus is Commander-in-Chief in the Constitution. The year is 1861. Lincoln has just been sworn in as the 16th President of the United States, and he has a crisis on his hands. 7 states had already seceded from the Union. He had just declared that null and void in his inaugural address. He's got a very pressing problem in one of those states, South Carolina, Charleston Harbor. You've got Fort Sumter right in the middle there. This is the last military base of any kind that was still in control of the Union Army in any of those seceded states. You got Major Robert Anderson in charge, but he's got to figure out what to do because he's running out of food, and the Confederates had surrounded Fort Sumter. So Lincoln had to figure out what to do, and he called together his cabinet. Now, you remember, Lincoln had never been an executive before, and he'd only served in Washington once before for just a couple of years, so this was very much new to him. And he wanted the best people around him. So he put together an all-star team, but what would later be called a team of rivals. There were a lot of presidential aspirants in this group, but Lincoln didn't care. He wanted the best advisors he could find. So he's got William Seward at the State Department. He's got Salmon at Treasury. Again, they never got along, but Lincoln wanted competence and good advisors, so he stuck with both for quite some time. Simon Cameron got the War Department, Gideon Wells at Navy. Edward Bates of Missouri was the Attorney General, really important advisor on these constitutional questions. Caleb Smith, Interior Department, and Montgomery Blair was the Postmaster General. They're all Republicans now. You had 4 former Democrats, 3 former Whigs. But in the end, as William Seward would say, the only decision, the only point that really mattered was that of the president. According to Seward, there is but one vote in the cabinet, and that is cast by the president. Abraham Lincoln would make these decisions himself, including this first one, whether or not to resupply. Now, the military situation was kind of bleak for Lincoln. The entire U.S. Army had only 16,000 soldiers. Many of them, in fact, most of them were out west, guarding the frontier and protecting against Indian attacks, and a lot of them were leaving to go join the South. So very small Union Army at his hand. General Winfield Scott had been the leader of that army for decades, and his advice to Lincoln is, you can't effectively resupply Fort Sumter. It's a military impossibility. Got the cabinet together. They voted 5-2 not to reprovision. But Lincoln said, doesn't matter, that's what I'm going to do. We're going to reprovision Fort Sumter, and he actually issued that order on April the 6th to resupply, gave that notice to the South Carolina Governor Andrew Pickens, and the South Carolinians said, look, you're a foreign territory on our land. You're not going to reprovision anything, and we're not going to let these people stay here. They opened up on Fort Sumter, a bombardment on April the 12th, and the Civil War had begun. Now, this all appears to somewhat have fallen into Lincoln's plans. Now, you got to remember back to Lincoln's term in Congress. What was he most known for? Attacking President James Polk over a very similar situation where Polk had, in Lincoln's mind, baited the Mexicans into coming to attack the Americans to start the war, so he could claim they came onto our soil, attacked us, therefore we're justified in going to war against Mexico. And Lincoln decried this. It was his main issue when he was a congressman, said it was both false, immoral type of action on behalf of the president, but now he's the president of the United States himself. And Lincoln said that when he called a special session of Congress together, he told that special session, by the affair at Fort Sumter, the assailants of the government began the conflict of arms. Lincoln decided to reprovision, the Confederates attacked. Sounds kind of similar to what James Polk did, but this was where we were here in 1861. Now, Lincoln actually went for a little bit further in some of his messaging in terms of his strategy of this. He wrote to Gustavus, Fox, you and I both anticipated that the cause of the country would be advanced by making the attempt to provision Fort Sumter, even if it should fail. And it is no small consolation now to feel that our anticipation is justified by the result. Strategy. He then wrote Orville Browning, the plan succeeded. They attacked Sumter. It fell and thus did more service than it otherwise could. Again, eerily similar to what he had criticized James Polk for, kind of fallen right into his plans. Maybe he had learned something from Polk along the way. Well, to Lincoln, what did this all mean now? So he has his rebellion. He looks to the Constitution. What rights did he have? And essentially what Lincoln would conclude throughout the war, that he had effectively unlimited authority to do whatever he wanted to suppress the rebellion in his role as Commander-in-Chief of the Army, Navy, and Militia when called into national service. Well, this was hardly clear from a constitutional standpoint, but Lincoln didn't pause. He not only he went and put an immediate call out for 75,000 volunteers. Again, Congress is not in session, so he doesn't have any congressional authority to do these actions. But he went forward anyway. It's a crisis, and as president, he needed to do something. He called up 75,000 men, and his biggest focus was that middle part of the country, including Washington, D.C., the nation's capital. He's now surrounded because 4 more states have seceded, including Virginia, right on his border. He's got Virginia there, and even in Maryland, which is not seceded yet, but slavery was permitted there. In the city of Baltimore, a hotbed of Confederate support. He's very nervous about the capital. He's nervous about Maryland and Delaware and Kentucky and Missouri. He's got to get those troops in place and try to at least keep those from seceding, build the line, and then go and attack to suppress the rebellion. These are the actions that he took, but he went even further than that. He would not go to allow any dissent or support to the Confederates in the North at all. He would use the full power of his office, and only a couple weeks after Fort Sumter fell on April the 27th, Lincoln issued an order to suspend the writ of habeas corpus, starting with the travel corridor from Philadelphia to Baltimore and Washington, anything he had to do to protect that space out of a military necessity. In fact, arrests would begin almost immediately, and the rules were, under Lincoln's order, that people could be held without charge indefinitely, and they would be tried in a military court, not have access to the civilian courts. In fact, one of the ironies of all of this is a lot of those who were arrested were held in Fort McHenry. Fort McHenry, right outside of Baltimore. Bit of irony is this the scene in the War of 1812 at Fort McHenry, a staunch defensive battle by the United States, was the inspiration for Francis Scott Key to write the American national anthem, the Star-Spangled Banner. Fast forward to the Civil War, and Fort McHenry is housing these civilians who have not been charged with anything, including Key's grandson, Frank Key Howard, who happened to be a newspaper editor from Baltimore, held for months without charge at Fort McHenry. Among those arrested was John Merryman. Now, he had been accused in Maryland of both drilling troops and providing other aid to the Confederates, and he had been arrested. Well, the case that he appealed went to the Chief Justice of the Supreme Court, Roger Taney. Taney, in this case, was actually presiding in the circuit judge in that capacity when he got this case, and he gave an immediate order to try Merryman in a regular court, civilian court, or he had to be released. Well, the military commanders completely ignored this. They had their orders from the commander-in-chief. So Taney issued what was called ex parte Merryman, a very bold statement. It said, these great and fundamental laws have been disregarded and suspended like the writ of habeas corpus by a military order supported by force of arms. I can only say that if the authority which the Constitution has confided to the Judiciary Department and judicial officers may thus upon any pretext or under any circumstances be usurped by the military power at its discretion, the people of the United States are no longer living under a government of laws. But every citizen holds life, liberty, and property at the will and pleasure of the army officer in whose military district he may happen to be found. Obviously, this is a really bold statement coming from the Chief Justice of the United States, which the Commander-in-Chief, Abraham Lincoln, simply ignored. Now, it's an interesting phrase here. As Merryman talked about, no longer living under a government of laws. Think back to Abraham Lincoln's very first political address, decades earlier. Of course, things change, but decades earlier, what did Lincoln focus on? The perpetuation of our political institutions based on the almost nearly religious adherence to the rule of law. He called it the political religion of the nation, and to worship upon its altars on the imperative of following the law. And he now has the Chief Justice of the United States basically accusing him as president of violating and ignoring the law, but Lincoln held fast. He had a crisis, he was the president, he would remain defiant. Now, what does the Constitution actually say about these areas that Lincoln was potentially violating? Well, we can look. Article 1, Section 8, to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. Article 1, Section 9, the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. So what's the problem? These seem to be consistent with what Lincoln was doing. Well, the problem was that these were not in Article 2, powers of the presidency. These were in Article 1, the powers of Congress. And it was pretty clear on a separation of powers standpoint, this was not Lincoln's authority as president to do those things during a time of rebellion or insurrection. It was the authority of Congress to do them. So Lincoln addressed this. He had just called a special session of Congress together, and he told that special session that now it is insisted that Congress, and not the executive, is invested with this power. But the Constitution itself is silent as to which or who is to exercise the power. And as the provision was plainly made for a dangerous emergency, it cannot be believed that the framers of the instrument intended that in every case the danger should run its course until Congress could be called together, the very assembling of which might be prevented, as was intended in this case by the rebellion. Now there's two aspects of Lincoln's defense here. One is that the Constitution is silent as to who has this authority, and the second is that emergent circumstances, if Congress isn't around, somebody's got to do something. Let's break this down. Well, the first one is frankly nonsense. Now, Abraham Lincoln, honest old Abe, he got that reputation for a reason. He was honest old Abe. Disingenuous was not a comment that would typically ever be used associated with comments from Abraham Lincoln. But that is the right word in this case. This excuse that it was unclear in the Constitution who had this authority is clearly a disingenuous statement. Article 1 is all about the authorities of Congress, as Article 1 begins with asserting that all legislative powers herein granted shall be vested in a Congress of the United States. Just like Article 2 begins, the executive power shall be vested in a President of the United States. And Article 3 begins, the judicial power of the United States shall be vested in one Supreme Court. Separation of powers is baked into this document and into the structure that was adopted at the Constitutional Convention. It is clear that anything that is not specified that Congress in every element of Article 1, it is the power of Congress to do these things if it's in Article 1, unless specified otherwise, and the same would be about the President in Article 2 and the judiciary in Article 3. Just look at Article 1, Section 9, the one about the habeas corpus statement that we just read. Well, what comes right after that? No bill of attainder or ex post facto law shall be passed. What's after that? No capitation or other direct tax shall be laid. What's after that? No tax or duty shall be laid on articles exported from any state. Well, based on Lincoln's logic, the executive could somehow do those things as well because it doesn't specifically say that Congress shall. Clearly, these were authorities given to Congress by the Constitution, and Lincoln had simply usurped them. Now, but let's go to the second part of his argument. A crisis. Congress is not in session. What am I supposed to do? I'm the president. I've got to do something. This argument has a lot more merit. But then he called a special session, and in that special session, Congress actually gave him a lot of the authorities that he had asked for, including the ability to raise the militia, to bring out volunteers, or to bring out people, and to have an appropriation to pay for them. Congress authorized these things. But one thing they did not authorize, the suspension of the writ of habeas corpus. They did not authorize that for 2 more years. So eventually they did. Eventually Congress took that act because it was their act to take. Nevertheless, throughout that entire period, Lincoln continued to have the writ suspended, people arrested, held without charge indefinitely, tried in military courts. This was a blatant usurpation of power, but Lincoln felt, in this case, the end justified the means. He had a greater goal. If he had to sacrifice part of the Constitution in order to win the bigger battle, then that's what he was going to do, and that is what he did. Now, the problem with this is, what does this mean for other commanders-in-chief? And this is something that we'll have to talk about as well, because is this setting some kind of a pattern that could be used in the future? And if we look in the past, there was one example that could have taken on this position. James Madison. He was president during the first war under the Constitution, the War of 1812, and there was a ton of dissent, particularly in the North, relative to his actions as president during this war. Very anti-war. And what did James Madison do? Absolutely nothing. He did not try to suppress dissent. He hated it, but he allowed it to continue because he was the father of the Bill of Rights. He had written the First Amendment, and he was felt bound to support it and at least tolerate this kind of this kind of objections that were coming into the marketplace and in the press, Abraham Lincoln took a different point of view. He had to suppress that dissent, and he took the power to do it, whether it was given to him in the Constitution or not. There was another former president who talked about this as well. This is a living former president. Franklin Pierce had just been in the White House 4 years before Abraham Lincoln, and he was appalled at Lincoln's actions as president. Now, these two were very different politically, and so they had different backgrounds and points of view, even though Pierce, also from the North, he was a Democrat. It was considered to be someone quite sympathetic to the South, but he also was much more of a strict constructionist than Lincoln. And Pierce said, "Is not this the worst form of despotism?" And he was talking about a time when Lincoln, a little bit later in the war, declared martial law across the Union. And again, Franklin Pierce said, "Is not this the worst form of despotism? Martial law declared throughout the land, with the additional appendage of a band of prejudiced, passionate, irresponsible abolition office holders constituted as a special corps of accusers. Let there be no more talk of sovereign states, of constitutional rights, of trial by jury, of legal protection for persons and property." He attacked the president on constitutional grounds, but again, Lincoln was very solid in doing what he thought was right. Lincoln would later say that as Commander-in-Chief of the Army and Navy in time of war, "I suppose I have a right to take any measure which may best subdue the enemy." Take a look at that statement. This is one of the most despotic statements ever made in the history of the Republic. Folks like Patrick Henry at the time of the founding would have been rolling over in their grave if a president of the United States, under any circumstances, was able to throw out all the constitutional protections at time of war. That was what they feared the most. Despotism to come out at time of war when the army has to answer to the commander-in-chief. This was one of their greatest fears. But for Lincoln, again, the greater good is what mattered, and he would make this point as well. Eventually, Lincoln actually put it all on the table in a very straightforward statement. Was it possible to lose the nation and yet preserve the Constitution, he asked. By general law, life and limb must be protected. Yet often a limb must be amputated to save a life. But a life is never wisely given to save a limb. I felt that measures otherwise unconstitutional might become lawful by becoming indispensable to the preservation of the Constitution through the preservation of the nation. Right or wrong, I assume this ground and now avow it. Lincoln believed that it was okay to break the Constitution in order to save it. And maybe he was right. I mean, after all, Franklin Pierce's administration certainly didn't do any good to solve the problems between North and South. If anything, it accelerated the path to a civil war. And Lincoln ultimately achieved the two most significant outcomes of any president in American history. He preserved the Union and he freed the slaves. So what's the problem? Again, the problem is the potential for others to use this same thought process. Imagine a future executive during a war to actually incarcerate an entire race of American citizens. That happened. What about another future president and another future of war who found a lawyer who told him, you know, based on the Constitution, you're commander-in-chief, you can do anything you want, so let's just go ahead and torture our captives, even though we have laws that say that we can't. This is the danger of having these despotic tendencies and to toss aside constitutional protections even during moments of crisis like this. But this was the tension, and Lincoln clearly came down on the side where the greater good, the end justifies the means. He had no choice. He was going to take these actions and do anything he could that he believed was necessary to preserve the Union. By the way, that last statement that Lincoln was making wasn't about the suspension of the writ. It wasn't about dissent. It was about emancipation, which was a topic that we're going to talk about shortly. Once again, another area where Lincoln would take on authorities, constitutional or not, to move forward out of military necessity, but we'll get to those stories in another day. That is Abraham Lincoln, the Commander-in-Chief and the Constitution from the life of Abraham Lincoln. For more presidential chronicles, check out my books on Amazon.com, and don't forget to subscribe to my YouTube channel. Until next time, I'm David Fisher, and this is Presidential Chronicles.